that day. I'm sure Mr. Fahey, to a certain extent, wishes he had stayed in the house that day. So, there is a limited incident that we're before Your Honor on, and I've laid out why we're here.
Court will take a brief recess to consider.
All rise. Court now stands in recess.
That I've heard so far, so sitting in chambers considering everything that I've heard so far, if I would take another hour or two, I'm sure I can take my notes and my thoughts, put together something that would be the response that I'm aware of the time. The fact that I think this decision that we make this decision. Unlike other states, accelerated rehabilitation and it does not require an admission to jail. There are other states that require an individual to see something before they are granted version. AR does not require that. But in order to apply for AR, there has to be an acknowledgement on some level that a crime, an actual crime, has been alleged. I would indicate that in the time that I spent at the bench, and currently the party judge here in the Judicial District, I oversee the disposition of murder cases, kidnapping cases, sexual assault cases, gang-related cases, racketeering cases. I've been examined that for 4 years. I oversaw each of the restraining order docket, and so protective order docket, and those dockets, various difficult dockets for judges. The allegations of all the terrible people the request for protection of the courts, of the police. And without exaggeration, I can say that this is likely the most contentious matter that I have to deal with in the time that I've spent on that. I understand that people, folks, the parties feel very strongly about their positions. I wish that there was something that I could say that would de-escalate the situation. I don't know if that's possible. I certainly share Attorney Fahey's who indicated his position that de-escalation, I think, is what everybody needs, what would be best for everyone. But I'm not sure, as I said, that that's possible. And, Mr. Reyes, I appreciate your candor and your eloquence. I listen very carefully to your statement and your position. And I agree with you that spitting, being spat upon, the act of spitting on an individual is a vile and degrading. It's vile and degrading, or intended to be degrading. I understand that outside of the assault on a public safety officer statute, that the spitting on individuals is not criminalized in Connecticut. I'm fairly certain in other states that spitting on another individual, not a public safety officer, a public safety officer is a very, very, very broad category. Not just police officers, but also healthcare workers, BCS workers. I'm not going to get into the policy considerations that bodily fluids in that statute. I don't think it's intended to undercut how degrading an act is to spit on another individual. I think that we all understand that. We all should understand. And hopefully, Mr. Fahey, the defendant, I'm told that he regrets what happened that day. It does not undercut as something vile and degrading. Yes, I have sat for many years and many times in VA and have been presented many applications on accelerated rehabilitation. And As a jurist, I understand that it is within my discretion to grant or not grant AR, that the legislature, the appellate court, and then the Supreme Court have afforded wide discretion to the court in granting accelerated rehabilitation. And I have been a criminal defense attorney. I have worked with other judges. I know that every judge differs on cases that they think are too serious to grant AR to the legislature. The appellate court and the Supreme Court, they typically defer to the court and those decisions. And while I'm not intending to claim my position among the more lenient of those judges, I will note that, and I will accept, but I will accept that I am a judge inclined to grant accelerated rehabilitation in many, or not most of the cases, presented with those applications. Because in order to be eligible for AR, you have to have no record, no. The charges cannot be precluded by the statute. There are charges for which you cannot get AR. And I've often heard it argued that the possibility of the individual ending up with no record seems unjust, that diversionary programs is just a slap on the wrist. And my position is that if one acknowledges that an actual crime has been alleged, that individuals are not asked to admit guilt, and the goal is to have no record of that alleged actual crime on their record, that there would have to be something that individual would have to do to confirm that, as opposed to it just being granted in the ordinary course, as if it were not ultimately serious matter. As a judge, I have tried throughout my career to listen very carefully to everything that's been said. Oftentimes I have found that individuals want to be heard, and having been a defense attorney, I've seen judges not pay attention. But I also understand that hearing someone's position, acknowledging that the validity of that position, agreeing with some parts of those positions, does not always mean that I, the court of court, is going to do what that person asked the court. So my job, if my decision differs from what I've been asked to do, is to explain my position, while letting everybody know or feel that I heard, I hear it, I heard it. The background of the case, the conflict in the case, creates a serious matter for the court to address. Any decision the court makes is probably not going to de-escalate the situation. On discharge, even taking into account that day in, on a day-to-day basis, what would this court do? Any honest answer from my perspective, the right thing is to grant the court. The request was for 90 days. I think that's a 90-day program with the background of this case, the contentiousness of the case, I think that trivialized what occurred. And I think that a lengthier period of AR would be appropriate. My understanding is that there are other matters pending in other aspects of the court. There's a civil matter that will probably go on for quite some time. I agree with Attorney Fahey that the parties should stay away from each other and certainly do everything they can not to be, and the court will do what it can to make sure that they are not in the same place at the same time. But through the AR period, I know that Mr. Reyes would then have some protection from Mr. Fahey in terms of an order that would require Mr. Fahey to initiate no contact with them. And that may allow some breathing space in order for the civil matters to resolve without the possibility of contentiousness that would be inappropriate and would result in a violation of the accelerated deportation. And so I will find that the charges against Mr. Fahey are not so serious as to include the grant of JR. And I will grant accelerated deportation for a period of 18 months. That is 6 months longer than the average grant of AR. Is to incur no arrest for which qualifying probable cause. Is to initiate no contact. And given the nature of the disorderly conduct, the allegations, I want to engage any counseling and treatment directed by adult stage. If there's some anger management or counseling that would be helpful to Mr. Fahey going forward, the law is clear that these officers are held to a higher standard than other individuals with regard to their interactions with others. I realize the complicated context of everything, but I agree with Mr. Reyes. I think the spending in some spaces is disgusting. That work 18 months. April 9th of 2027. And the matter is returned to court. They are to be terminated. And the questions of guilt not required by AR would then be settled by a jury of Mr. Davis. So there's nothing further from the party?
Nothing, Your Honor.
We are adjourned.
All rise. Court now stands.
Alright, fellow patriots, the courtroom footage is courtesy of Justice Served TV. I'll leave a link to their channel in the description below the like button so you can check out their exclusive after-court interview with yours truly. So to summarize the proceedings, the former disgraced police sergeant Brian Fahey and the state were asking for a 3-month probationary period, with the case being dismissed after the completion. The judge ended up granting the diversion program, but extended the probationary period to 18 months and recommended counseling such as anger management or mental health. Now, do I agree with the judge's decision granting the accelerated rehabilitation? Obviously, I do not. I just want to make sure that the blame goes to the right person. State's Attorney John Fahey had a constitutional obligation to charge Brian Fahey with felony threatening and reckless endangerment in addition to the disorderly conduct charge. He failed to honor his oath. I think his reasoning on why he only charged disorderly conduct was disingenuous at best. It's unfortunate that Brian Fahey won't be held accountable in a criminal court with a public trial. But at least we the people not only exposed the deranged psycho and got him to retire, we also exposed a biased state's attorney who doesn't honor his oath, and the rotten police department who conspired with Fahey to violate not only my constitutional rights but my cameraman's as well. Fortunately, Fahey has already been denied qualified immunity in my first federal lawsuit against him, and as soon as my charges are dismissed, and I am confident they will be, I will be filing another one. I promise each and every one of you that I will do everything in my power to make sure Fahey is held accountable in a civil court of law. Make sure you're subscribed. We the people are almost 1 million strong. I truly appreciate all of your support. We take on tyranny together. I couldn't do this without you. United, we are strong. Stay tuned to make sure to have notifications turned on so you don't miss any upcoming videos. Let me know your thoughts on this one in the comment section below. As always, stay safe. God bless. I'll see you in the next one. Long Island Audit. Peace.
He was